Welcome to the My Citizen Agency channel. Today we'll talk about a topic that our clients often ask us about. How can you find out if you are eligible for the simplified program? Many people have heard that in some EU countries it's possible to obtain documents more quickly or follow a simpler application process if you meet certain eligibility criteria. But when you start looking into it, many questions arise. What specific grounds qualify? What documents are needed? How to verify family history? Is a surname sufficient in an archival record? What to do if documents are lost, and is it possible to assess your chances in advance? In this video, we'll discuss what to look out for before starting the process, what mistakes most often trip people up, and why it's important not to draw conclusions based solely on relative stories or information from the internet. Let's clarify an important point right away. Each European Union country sets its own rules. Therefore, there is no universal answer that works for everyone. The simplified program always depends on the specific country, the specific grounds, and the specific set of documents. When we say simplified program, we mean a legal process where someone can obtain status, citizenship, a residence permit, or another official document based on their origin, family relationship, historical affiliation, restoration of lost status, or other criteria set forth by the law of a specific EU country. In other words, it's not simply a desire to migrate, nor is it a situation where a person chooses a country solely because they like the climate, standard of living, or prospects for their children. A simplified program requires that the applicant have a legal basis. Simply put, the state must recognize that you have a connection to that country, and that this connection is documented. And this is where the most important part begins, not just what was told in the family, but what can be proven with documents. The grounds for eligibility under the simplified program in EU countries may be different. Most often, they relate to ancestry, the citizenship of ancestors, the place of birth of relatives, historical events, loss of citizenship, family circumstances, or other legally relevant facts. For example, in some cases, it may be significant that your parent, grandfather, grandmother, or a more distant relative was born in a specific country or held its citizenship. In other cases, not only the place of birth, but also nationality, documentation, date of relocation, reason for loss of citizenship, or the availability of supporting archival materials are important. This is precisely why you cannot assess the situation based on a single fact. For example, the phrase "my grandfather was born in Europe" does not guarantee anything on its own. You need to understand where exactly he was born, in what year, what territory it was at that time, what citizenship he held, what documents have been preserved, whether his citizenship changed, whether there were official records, and whether they can be obtained now. The same family history may provide grounds for eligibility in one country, but not in another. Therefore, the task at the first stage is not to guess, but to gather facts. Before consulting archives and lawyers, it's helpful to do some preliminary research at home. Talk to your relatives, especially the older generation. Write down everything they remember: full names, maiden names, dates of birth, places of residence, dates of marriage, relocation, military service, education, and employment. It is very important to record not only the exact data, but also variations in spelling. Surnames and first names could have changed due to moves, transfers, changes in documents, or errors in records. Sometimes a single letter in a surname is the reason why an archival search yields no results, even though the document in question exists. Also pay attention to family documents: birth, marriage and death certificates, old passports, military documents, employment records, diplomas, certificates, archival extracts, records of name changes, and relocation documents. Even if a document seems unimportant to you, it can become part of the chain of evidence. In a simplified program, it is often not a single document that matters, but the sequential connection between generations. For example, a document for an ancestor, then a document confirming the ancestor's connection to their child, then the connection to your parent, and only then to you. If there is a gap in this chain, it must be filled with additional materials. Family history is a good starting point, but for the official process, you need documents. Government authorities do not make decisions based on oral accounts, even if they are true. A common situation: a person is convinced they have grounds for their claim because it has always been discussed in the family. But upon verification, it turns out that the necessary records are missing, the territory belonged to a different country at the time, the surname is listed differently, citizenship cannot be confirmed, or the required line of descent cannot be proven. The opposite also happens. A person thinks there is no chance because the documents were lost long ago. But after an archival search, records of birth, marriage, residence, or civil status are found, which open up the possibility of participating in the simplified program. Therefore, the main principle is: do not draw final conclusions before a documentary check. The list of documents varies by country and program, but several categories are typically reviewed. The first category consists of the applicant's documents, birth certificate, passport, and documents regarding marriage or a change of surname, if applicable. The second category consists of the parents' documents, birth certificates, marriage certificates, certificates of change of surname, and sometimes documents regarding citizenship or place of residence. The third category consists of documents related to the ancestors on whom the application is based. These may include birth certificates, marriage certificates, archival records, registration records, citizenship documents, residence records, and military or administrative documents. The fourth set consists of documents that connect the generations. This is particularly important. Even if you have an archival record for your great-grandfather, you must prove that this person is indeed your direct relative. To do this, a chain of documents is compiled from him to you. The fifth category consists of documents that confirm the absence of contradictions. For example, if a surname is spelled one way in one document and another way in another, you may need an explanation, an additional certificate, or a document confirming a name change. When it comes to the simplified program, dates and territories are of paramount importance. The borders of European countries have changed, as have their administrative divisions, and the same city may have fallen under different jurisdictions at different times. Therefore, the phrase "born in this or that city" requires clarification. In what year? What was the name of the territory at that time? What legal system was in effect? What documents were issued? And where to look for archival records now? It is precisely at this stage that many people make a mistake. They look at a modern map and draw conclusions based on today's borders. But for a legal assessment, the map and legislation of the specific period when your ancestor was born or lived are often important. Therefore, a professional verification includes not only the study of family documents, but also an analysis of the historical and legal context. Just because you don't have documents at home doesn't mean there's no evidence. Many records may have been preserved in national, regional, church, municipal, or specialized archives. Sometimes records aren't located in the country where a person currently lives, but rather where the event took place: birth, marriage, registration, military service, or residence. If there are no documents, it's important to start by reconstructing the basic chain: your birth certificate, your parents' documents, then your grandparents' documents. After that, you can figure out which direction to look in next. But it's important not to send out random requests to every possible archive. It's better to first create a clear picture: who was born where and when, where they lived, what surnames they used, and which events need to be confirmed. Then the search becomes more precise. There are several situations where it is definitely worth conducting a preliminary analysis. First, you have direct relatives who were born or lived in an EU country or in a territory historically connected with that country. Second, your family documents contain records of nationality, citizenship, place of birth, or old administrative names that may be relevant. Third, your family has kept old certificates, passports, archival records, military documents, or documents regarding marriage or relocation. Fourth, relatives have spoken of the family's European origins, but you have never verified this with documents. Fifth, you've already conducted an archival search but received an incomplete answer or don't understand how to interpret the documents you found. Sixth, you have scattered documents, but it's unclear whether they form a legally significant chain. In all these cases, it's better not to guess but to conduct an initial assessment. The first mistake is to start the process without doing any analysis. People immediately order translations, certifications, and certificates, send out requests, and then realize that they've chosen the wrong path or that the documents don't support the necessary grounds. The second mistake is relying on someone else's experience. Even if an acquaintance has a similar story, that doesn't mean you'll get the same result. In the simplified program, details are important. Dates, family relationships, documents, records, changes in surnames, and civil status. The third mistake is ignoring discrepancies in documents. Different spellings of names, different dates, missing middle names, mistakes in places of birth, all of this needs to be analyzed in advance. Sometimes a discrepancy can be explained, and sometimes it becomes a serious obstacle. The fourth mistake is to think that one document solves everything. In practice, a chain of evidence is often required. A document for an ancestor is important, but without proof of relationship, it won't work. The fifth mistake is trusting unverified information from the internet. Laws change, requirements are clarified, and the practice of reviewing applications may vary. Therefore, it's better to rely on current verification and documents. In our practice, the initial assessment begins with questions about family history and available documents. We determine which EU countries may be relevant, which grounds for eligibility are potentially applicable, which documents are already available, and what is missing. Next, we assess the line of family connection. It is important to understand exactly through whom the basis for eligibility can be established, through a parent, grandparent, or a more distant relative. After that, we verify whether the generations can be linked through documentation. Then, we analyze key documents, records of birth, marriage, name changes, citizenship, and place of residence. If there are insufficient documents, we determine where to look for them and what requests to make. As a result, the client receives not a promise that it will definitely work, but a clear picture. Whether there are potential bases, what documents are needed, what risks exist, and what next steps would be reasonable. If you want to determine whether you qualify for the simplified program, start with the basics. Collect all the family documents that you have at home. Write down information about your parents, grandparents, and, if possible, more distant relatives. Pay attention to places of birth, dates, surnames before and after marriage, old documents, and archival records. Don't throw away documents that seem outdated or unimportant. In these processes, even an old certificate, marriage record, or document stating a place of birth can turn out to be a key element. After that, it's best to get a professional assessment. An expert will help you determine whether there's a potential basis for your claim, which EU countries to consider, what documents need to be restored, and how realistic the next steps are. The simplified program is all about documents, facts, and a correct legal assessment. To determine whether you have a valid case, you need to answer a few key questions. Which of your relatives may have a connection to an EU country? What evidence supports this connection? Can you prove the family relationship? Do you have sufficient documentation? Are there any discrepancies? And what requirements apply in the specific country? Don't give up on the idea just because you don't have the documents, but you also shouldn't start the process blindly, relying only on family stories or someone else's experience. The right first step is a preliminary assessment of your situation. If you're just planning to immigrate to the EU and want to understand whether you have a realistic basis for applying for citizenship, submit a request for a free consultation via the link in the description. We will review your situation, create a personalized immigration plan for you, and prepare a complete set of documents to successfully obtain citizenship in one of the EU countries. We work on a one-on-one basis, taking into account your goals, your lifestyle, and your specific circumstances. Thank you for watching this video. If you're interested in this topic, subscribe to our channel and feel free to ask questions in the comments. We'll regularly publish program reviews, answer frequently asked questions, and share important news about immigration law and life in the EU. Your journey to Europe begins with the first step. My Citizen Agency is here for you, every step of the way.